You're listening to Cover Your Assets, a podcast that discusses the timely and significant legal issues faced by employers. Kathleen Jennings is an attorney who has over 30 years of experience in advising employers as to their legal responsibilities and has written extensively about employment law in her popular Cover Your Assets blog. If your business has employees, you cannot afford not to have your assets covered.
Hello, everyone, and welcome to the latest episode of Cover Your Assets, the labor and employment law podcast. And before we begin, of course, we want to thank everybody for tuning in, for listening, for sharing. As of now, I don't think that I've shared this fact with our resident expert, Kathleen Jennings, but we're going to start out with a quick little trivia question. Which of our episodes from the archives do you think has had the most listens? Which of the episodes? Go ahead.
I'm going to guess the same-sex sexual harassment.
That would be number 2.
Oh,
yes.
That was number 1 for a while. So I'm wondering if it is the workplace romance episode that featured quite prominently the sex police.
The sex police which should have been our number 1 episode, but no, it's not.
Well, then I'm stumped, Tom. Tell me.
It is restrictive covenants.
Really?
Yes. So
that is interesting.
Yeah. So maybe it's a topic that has not been broached. Is that the proper terminology? Very often in podcasts, but nonetheless, that is our number 1. But the point being is that you should go back, listen to our archives because they're all great episodes, and you'll find a lot of great information.
And we're not biased at all, are we?
Not a tad. Not
at all. No. We have, what I have to say, Tom, I have truly enjoyed doing these episodes with you, making these episodes. So if our audience enjoys listening to the episodes half as much as we have enjoyed making them, then they will have a good listen.
Now that, of course, Kathleen, for those who are tuning in for the first time, I'm Thom Jennings. It's my sister, Kathleen Jennings, and that sounds like something our mother, Elizabeth Jennings, would have always said. If they enjoyed half as much, yes, that was very much, you channeled our mom in that statement. It was beautiful, though. It was touching.
Well, what can I say? She raised me. She raised you. Look how we turned out. We'll leave it at that.
And 2 minutes in, let's introduce the topic. The topic is constructive discharge. Now, the term constructive discharge, I'm going to be honest with you, the first time that I ever heard it was about an hour ago when we were doing a little bit of our pre-show powwow. And even though it's not a term that I've heard of, I've certainly experienced it, and I think it's something that almost anybody that's ever had a job at a place with more than a handful of employees has witnessed something like that happening. So constructive discharge, this is a legal term, correct?
It is a legal term, a sort of a term of art, and it's defined as a constructive discharge is when a worker's resignation or retirement may be found not to be voluntary because the employer has created a hostile or intolerable work environment or has applied other forms of pressure or coercion, which forced the employee to quit or resign. And I guess what it is you could call it almost a cowardly way for an employer to terminate an employee without doing it directly. It's basically indirect termination when a resignation or retirement is found to be a constructive termination.
And you use the term cowardly, but let's be honest. It's difficult to terminate an employee. I mean, in any situation, unless it's very cut and dried, like theft or violence or drug use, things like that. So, but yes, I mean, obviously, as an employer, you have to be very cognizant of, like we discussed in a previous issue, dealing with terminations in a very respectful way. So, but we've all heard of those situations where it's like, why don't we just get employee X to quit because they're driving everybody crazy. And it almost seems like to me, in many cases where a company tries to get an employee to quit, it's not because of one particular episode or incident. it's more or less just maybe they just don't like that employee, or again, this could go to retaliation. I mean, there's so many circumstances that come up, but to me, it seems like the most common one would be, we just don't like this person, we want to get him out, and we don't really have a reason to fire him, so let's just make things unbearable so that they'll quit.
That's probably a good summation of why an employer would go through this process. I would not recommend it as a way to have an employee leave your employment. If you don't have a good reason to terminate someone, then doing it in a way that, if you do it wrong, appears to be dishonest is only going to draw a lawsuit. And in that lawsuit, you have to think about, how's the company going to look? This is a company that is purposefully making a work environment difficult or intolerable. And that's going to be a hard case to defend. So whenever employers do things that are not direct or honest, then you start seeing lawsuits, charges. You may have a jury trial, and think about how that's going to look. So if you have a problem employee that you want to leave your employment, there's probably, yes, it's difficult to terminate folks, especially in states. Here in Georgia, we have pretty much pure at-will employment. You can terminate an employee anytime for any reason or no reason at all. Up there in New York, at-will employment is not quite so pure. And then you have situations where people are in protected classes, so federal law would apply. If you have a unionized work environment, then you have to work within the parameters of the collective bargaining agreement. So yes, it is difficult in many cases to simply just let someone go.
Yeah, and I mean, I've heard of scenarios and maybe witnessed scenarios in different places where I've worked at where supervisors have said, well, we just need to start writing them up. We just need to start writing them up. So they're going to start looking for things to write the employee up. And where I imagine you could start getting into trouble for that is, let's say it's, we'll come up with lateness. So habitual lateness. And you start writing the employee up for being habitually late, but yet there's 7 or 8 other employees that are habitually late. Are those situations where you could really start seeing yourself getting into trouble in terms of if there's a court case or anything up the road?
Absolutely, because if you change the way that you treat an employee, or if you treat an employee differently than you treat other employees, if you're not writing up everybody else in the department for being late or not giving them a hard time for being late, but you have singled out one particular employee for being late, then you could run into problems. Now, if it's simply just singling out, is that discrimination? It really depends on how, if they are in a protected classification, or maybe they've complained about something. In a lot of cases, you'll see constructive discharge being alleged along with something like retaliation, because someone will claim, after I made a complaint or I became a whistleblower, after that, my employer started treating me poorly to try to get rid of me, because they know, or a smart employer knows, is you shouldn't dismiss someone for making a protected complaint. But by doing it indirectly, by making the work environment intolerable, that doesn't really help matters. I think it just makes it worse.
Yeah, in fact, I was just talking with somebody this past Tuesday and had worked with, I know every episode we usually share a personal story of situations that pertain to the particular topic, which I'll be discussing later, you will as well. But this young lady was telling me she'd worked at the same organization where I'd had the same situation in terms of the, trying to get me to quit scenario and the constructive discharge. And what she had told me is that she had reported it was a not-for-profit agency to the state. And it's the Justice Center is where you report if you think there's abuse to a particular client, if you're working with different types of individuals. And I'll try to use as little information as possible because I don't necessarily want the organization to be identified. But she had done this report. it had after that they stopped scheduling her regular shifts. So the way that they got her to quit wasn't necessarily by writing them up. What they did was they just weren't putting her on the schedule enough where she could justify working there anymore. So in that case, she just quit. Nothing really became of it. I don't know. She did tell me she wound up getting unemployment out of the situation after it was all said and done. But is that a fairly common form where you start saying, maybe you take away the overtime or you start taking away the actual shifts? I mean, is that something that can be proven in terms of a form of constructive discharge in a court setting?
Absolutely. Any time you change the work environment that's a way that negatively impacts on that employee, especially after, again, they've engaged in some sort of protected activity, that could be, if the employee resigns, that could be construed as a constructive discharge. I had defended a case involving an employee who, she was a poor performer. She was in attendance trouble. She was on the brink of being terminated. And then she complained about sexual harassment in the workplace by her supervisor. And she had the recordings to back it up. Now, this was, when we talk about sexual harassment, when you have the work environment where people are telling the dirty jokes or using the colorful language and nobody complains about it, that can be used against you at a later time by that employee who wants to protect herself from being terminated. And that's what this woman did. And then she also had a lot of health issues that required her to take a lot of time off, to be very close to a bathroom. She wasn't getting her job done because she wasn't there long. She just was never at work. But the employer was concerned about simply letting her go because she'd made that complaint. So they changed her to a different job in a different location of the facility and gave her her own dedicated porta-potty so she could be close to a restroom facility. Well, she was not happy about the porta-potty. She wanted indoor plumbing, and she ended up quitting and then claiming discrimination, retaliation, and constructive discharge. So that's a real situation.
Wow. I almost wonder if that would go into the like a medical issue, a HIPAA issue, because if you're putting somebody near a bathroom and everybody gets wind of it, they must know that, that was an unintentional pun, get wind of it. But if you're putting somebody near a bathroom, doesn't it almost make it known to everyone that there's some sort of health issue related to the fact that this employee has to go to the bathroom? Would that be another issue that could kind of get layered onto this whole scenario?
A lot of people apply HIPAA to entities that are not considered covered entities under HIPAA. And so this would not be a HIPAA violation. It's certainly a situation covered by the Americans with Disabilities Act because she had a condition that rose to the level of a disability. And this was a way for the employer to try to accommodate that issue. Basically, they created a job for her that was outside and not close enough to a restroom that they felt it important enough to actually purchase this or rent probably the porta potty solely for her. But not everybody loves the porta potty. I can tell you that having done multiple bicycle rides across Georgia, I have no problem with a clean porta potty when I need it.
Yeah, my wife will never use a porta potty ever.
If the choice is between a clean porta potty and a sketchy looking restroom in a janky convenience store, I'm going with the clean porta potty. I'm just putting that out there.
And of course, this is not related to the topic. It's constructive and it's dealing with discharge, but it's not constructive in terms of what we're talking about. So let's bring it back. What do you think?
Okay, let's do that. Sure.
Cover Your Assets, the podcast where we take some weird bunny trails, but that's okay because that's what makes it entertaining. So let's go back to the situation, porta-potty. And what came to mind when you started discussing the whole scenario with this particular employee is that in many cases it feels like, and I've seen this, witnessed it, maybe experienced it to a certain degree, that when you are getting to a situation with an employee where they kind of got to go for whatever reason, that's just not working out, they've created a toxic work environment, the whole 9 yards, that now it becomes a bit of a chess game. And I think employers would probably need to be very cognizant of that. So you mentioned, for example, here's an employee, they're starting to kind of do some things and showing the employer showing their hand, say, hey man, we're trying to get rid of this employee. And then the employee becomes aware of it, so they're going to start recording conversations. So what's your recommendation, again, at that, really to be proactive in terms of understanding that once the process begins, that it could really become an ugly interaction between HR, management, and the employee, and knowing, of course, that the employee is probably going to start telling every other employee in the place that listens what a horrible thing is happening to them at that particular time?
I think in this situation, that's where you want HR to try to do as much damage control as possible. And I will say, in this situation involving the woman in the porta potty, the employer was really not trying to get rid of her. They actually created this job specifically for her so she could stay on and keep her health insurance. But her perception of the situation was completely different. So it may be an issue of communication between the employee and the supervisor, between HR and the employee, so that everybody's on the same page that, no, we're not trying to get rid of you, but we do need somebody in your job who will get the duties done, and you're not doing it because you're not here.
And of course, she was able to get her duties done because she had a porta potty. I couldn't resist. It was there.
There you go, off on another rabbit trail. There you go again, Thom.
Well, I think, and again, one of the things that you mentioned in that perception, perception is reality. I mean, it's an old adage, but it holds a lot of truth to it. If an employee perceives that for whatever reason that they are being pushed out and that kind of stuff, I mean, that, to me, that just can create a whole bunch of layers of craziness in the workplace. So, and I wonder too, in terms of coworkers, things like that. I mean, would you entertain anything from a coworker who maybe comes in and says, oh, Joe's telling me all this stuff that's going on in terms of employee discipline. And actually, let me flip that back a little bit, because this is a scenario that actually happened at a place that I worked at. The HR person really probably should make sure that they're not telling everybody on site that this employee is going through any kind of discipline process or anything, or that they're trying to get rid of the employee. I mean, I worked at a place where the HR person really just loved to run her mouth. And if there was an employee that was written up, or there was somebody that they were trying to drive out, I mean, she would tell anybody that would listen. And I just remember at the time thinking, man, this is just a lawsuit waiting to happen.
It's a lawsuit waiting to happen, and it's certainly not the way that a good professional HR person would conduct themselves. A good professional HR person is not going to disclose any specific employee situation to coworkers without a really good reason. But no, that kind of behavior is not constructive. It's not good for employee morale, and it's just not cool.
And I think it underscores the importance of really having a good HR person. I mean, as a business owner or somebody that's in management or anybody that oversees HR, that position is, I mean, as much as you worry about employees being the ones that are the problems in terms of potential lawsuits and everything, it really does come down to having a very solid person, super professional, not gossipy or overly chatty in your HR position.
Absolutely. A good HR person should be familiar with the laws of your state, your jurisdiction. If they don't know something, they know who they can get in touch with. They probably review regular updates on HR issues and HR laws. Basically, if we want to wrap this thing up, Thom, a good HR person is critical to covering your assets.
Right. And they're listening to podcasts like this to get great advice and information, which is a combination. We offer a combination of both, and occasionally some storytelling from the archives of your brother. And with that, I will ask you to throw me a softball.
Thom, have you ever had a situation where you felt like you were a victim of constructive discharge?
Well, it's interesting that you asked me that. And actually, I touched on it earlier with the fact that I discussed it with another person when I at an employer that I dealt with constructive discharge from. And so I'll recap a little of that. I was working at a not-for-profit agency. And what had happened was there was a situation where I had discovered some documentation that was being altered. In fact, they had asked a whole core group of us to alter some documents that were being submitted for medical billing, and they had been filled out improperly. So we were brought into a room. We were handed a whole series of different colored pens, and we'd have to draw on the paper to make sure that the ink matched up with the original notes, and then we'd have to amend the notes so that they were able to properly bill. And the whole thing seemed very sketchy, and it was very scary. Now, we had recently had a presentation by the agency's compliance officer who said, hey, if you see anything that's not above board, please, by all means, get the information to me. I am above the company. I don't have to answer to them. I'm just here to make sure that everybody's complying with the law. And so in turn, what I did was I turned over clear evidence. Of course, did not keep a copy for myself because I was a complete moron. And said, here, this is the stuff that we did. This is the stuff that we amended. This was the date. These are the people that were there. And the compliance officer said, this is wonderful information. You have done your civic duty for this organization. You have saved us. I'm, of course, adding some stuff on. And lo and behold,
probably saved yourself from going to prison or something too.
Well, yeah. I mean, if nothing else, I felt a moral obligation because it was we were dealing with medical billing. I mean, that's fraud, and not that I don't.
And an orange jumpsuit would not be flattering on your figure.
But I think stripes would. I think up and down stripes, especially being that I'm a little overweight, they would thin me.
Vertical stripes always do that, yes. Make you look taller. Yes. Anyway, go on with your story.
So I thought I'd done the right thing. And in many ways, I was trying to cover my asset in that I didn't want to go to jail for any of this kind of stuff. Because, a lot of situations you'll see where there's fraud in an organization, it's usually not the big guys that go down. It's the little guys that go down because we were the ones that had the pens. Nevertheless, at that point, they had a thing that was called administrative leave, and it was paid. So, you'd go to work one day and they would just tell you, oh, you're on administrative leave because there was an accusation against you. You can't talk to any of your coworkers and you'll be out for a short period of time, and we'll call you when the investigator wants to talk to you, and then you come back to work. And so those started happening on a more frequent basis over the next, 3 to 4 weeks. And so I found, even though I was still getting paid, I was getting sent out of work, and it was situations where there was one of them where I was out of work for almost a week. And the incident that I was accused of happened on a day that I had taken a vacation day. So it wasn't even like there was any of these situations that were valid in any way, shape, or form. So one morning I came into work and they called me into the office and they said, you were supposed to drive some clients around today, but you're not allowed to take the company vehicle because a coworker reported that you have alcohol on your breath. I'm like, alcohol on my breath? I'm like, I don't have alcohol on my breath. said, if you want, I'll go right to the hospital up the road and have my blood drawn to prove that there is zero alcohol in my system. I said, I've had 3 administrative leaves over the last month, and I said, I think I know what's going on, but this nonsense needs to stop. And she's like, well, there's nothing I can do. The hospital thing, I don't know what to tell you. So I quit. And really the only thing that came out of it, I was able to get unemployment because they did determine, because of all the administrative leaves and all that kind of stuff, that it was, I guess the terms you use, the constructive discharge. But I wasn't up for dealing with a lawsuit or any of that kind of stuff. But that particular agency sort of has a reputation for that kind of thing going on, in terms of a lot of those administrative leaves and cutting hours and things like that if anybody complains. So I don't know. They're still in business. So I showed them.
You sure did. You sure did. I'm proud of you, bro.
But that is my story. I don't know if there's a moral to it. As I said, I did wind up getting the unemployment, so I'm assuming the agency, because I know in New York State, and I don't know how it is in other states, the employer is responsible for paying a significant portion of the unemployment. And I did my level best to stay on unemployment till the absolute last week that I possibly could to make sure that agency, I was like, I'll make them pay.
Wow. I think the moral of the story is that, here's an employee who was trying to do the right thing and he was punished for it. I would think that kind of information would get around and probably discourage other potential good employees from wanting to work there.
True. Yes. I will hold on to that. I mean, granted, this happened, man, it's got to be 18, 19 years ago. So don't look at my resume. Try to figure out where it was. But actually, I never put that place on my resume for that particular reason. But you only have to go back 10 years on your resume. What is that? That's a whole nother episode that maybe we should do.
That's, different places go back certain amounts of time on your employment history. The important thing is to not lie about it.
Well, very good. Anyhow, as always, a great episode. Certainly, I hope that people got something out of it. Don't forget to check out the archives. We have lots of other great topics that we've covered. And if you have anything that you want us to discuss, what's your contact information there, sis?
My contact information is my email, kjj@wimlaw, WIMLAW.com.
And what kind of services does your law firm offer to employers?
Our law firm represents employers in all types of labor and employment matters.
And, of course, the attorney that you want to contact at that law firm is indeed Kathleen Jennings. And how about a few takeaways before we say goodbye?
Don't try to do something indirectly that you can't do directly.
Okay. And, of course, if an employee needs a porta-potty, don't give them any crap about it. Just give it to them. All right. We officially got a laugh on microphone from my normally stoic sister. And with that, I will thank you for listening to Cover Your Assets, the Labor Law, Employment, and Porta-Potty Podcast. We'll see you next week.